One night in Townsville in February 2013, a group of young people looking for a car to steal found a Toyota Hilux dual-cab ute with the keys in it. They piled in. Willie Wosomo, aged 16, was the driver, and Alefeo Captain, aged 14, was a passenger. Wosomo was speeding, tried to make a late turn, and less than a kilometre from the theft, he ploughed into a light pole, leaving Captain with permanent serious disabilities. Captain sued in negligence. Justice Daubney found that Wosomo, the driver, did not owe Captain a duty of care. They were involved, together with the other boys, in the joint crime of stealing the car. Captain had done nothing to try to withdraw from the common criminal enterprise, and the court would not enforce a duty of care between thieves engaged in theft. He then indicated what his decision would have been about a number of other matters if he had found that a duty of care existed. This is quite common in case there's an appeal. One issue that had to be covered was the question of whether Captain had voluntarily assumed the risk associated with the crash. Justice Daubney found that he had not. First, his honour found that a reasonable person in Captain's position might not have appreciated the risk. He said, "The present case involved a 14-year-old boy. It is not at all apparent to me that the risk of the defendant driving the vehicle dangerously was one which would have been obvious to a reasonable person in the position of the plaintiff, exercising the ordinary perception, intelligence and judgment of a 14-year-old boy." Then he found that even if Captain had identified the risk, there was no evidence of him voluntarily accepting it. His honour said, "Even if it be accepted that the risk of the defendant driving recklessly or dangerously was a probable incident of the illegal joyride, there is no evidence from which it can be inferred that the plaintiff consciously agreed to accept the risk that he would be injured in a collision such as that which was suffered." From this case we learn that in negligence law a person cannot be said to have voluntarily assumed a risk unless they knew or ought to have known of the risk, and there is evidence that they agreed to accept that specific risk.